Hey everybody, this is Ryan McClanahan with historythroughcards.com. Hope you're all doing very well today. As you guys probably have figured out by now, I usually like to take the road less traveled when it comes to hobby history. And when I talk about ball players, I just don't like to talk about their careers because, quite frankly, their careers may be interesting if you're only into sports, but for certain ball players, their careers take a different avenue, and that's usually the one that I like to explore the most. And in this case, Larry Jansen here has a really interesting story when it comes to the right of privacy. Now, if you followed my channel for more than a day or two, you'll probably figure out that I really like to discuss legal cases and the laws surrounding the sports cards and the hobby. And in his case, he's one of the very few players to actually have sued a company, and he's not the first one. There's actually two other cases that I'm aware of where a ball player has sued a company. Actually, there's three, and Babe Diedrichson actually sued as well. And she's not in a whole lot of cards because of the right of privacy in 1932. And then prior to that, you have a gentleman by the name of Harry Porter, who sued American Tobacco Company, the American Lithograph Company, over his right of privacy, his image rights. And so you also have uh, Johnny Mize, who sued Gum Products Inc. or Double Play in 1941. And I wrote an article about that, pretty lengthy, in fact. It's kind of interesting where you have in the 1950s more ball players who are getting in on the Right of Privacy Act here. And Larry Jansen was one of the first to follow suit of Johnny Myers. Now, Larry Jansen probably didn't know anything about Johnny Myers' suit, although I'm not even sure that they were teammates at that point. He came up, I believe, in 1946. I could be wrong here because it doesn't say in the back. I'll show you the back of this card. A 1952 Bowman. It's actually a really nice set. Although, if you look at the 1951 or 50, and then you look at the 1952 Bowman baseball cards, the colors are going to be a little bit muted, I think. There's something definitely different with the colors on the 52. And it's a really interesting set all to itself because I don't think that the 1952 Bowman, I don't think that this was actually the intended end product. I've heard stories where 1952 Bowman actually wanted to enlarge their baseball cards to the size of Topps that year, and that never happened. Although I think we do have examples of that in proof form, and I think they're black and white. But in this case here, Larry Jansen actually was a pretty solid pitcher for the New York Giants and the winning pitcher in the 1954 World Series. And so I wanted to not just discuss his case, but also his career as well. He's also actually, he was, I should say, a very good signer through the mail, and he was very good to his fans as well. He passed away in 2009 at the age of 89, and he leaves a very interesting legal legacy here that I want to tell you guys about today. I'm not going to read the entire case. Actually, I'm not going to read the case at all. I will leave it down in the comment section below or the description below because if you guys want to read that, um, go ahead. But I didn't really find it all that interesting as some of these cases that I like to read here. I didn't really do anything for me. But I am going to read an article here that will explain a little bit more. It's quite interesting, actually, a lot more interesting than legal cases. Most legal cases, in my opinion, are pretty dry, pretty boring. What you might find kind of interesting here is the defendants in this case. They are going by two different company names. Actually, it may be two different companies, but you'll recognize the card in which Larry Jansen is involved in, his name and likeness, and that is actually Burke Ross. Now, I kind of caught this because it says actually Burke Ross here, and this is Nellie Fox, and this looks exactly like his rookie card from the 1951 Bowman set. I actually have his rookie, and he's a different uh, subject altogether here. But what they are talking about is the Burke Ross set, the 1952, in fact. And this one is kind of interesting because the photo is Nellie Fox, Hall of Famer, but the back is Ewell, the Blackwell, and you can see that right here. I'm sorry, my camera does not like to pick up baseball cards, though I do. So anyway, let's get on to the article here. I really think that you're going to find this really interesting portion of the hobby history. So let's get on to it. This is from the Marquette University Law School. Does Larry Jansen belong in the Right of Publicity Hall of Fame? By J. Gordon Halton, October 16th, 2009. Former Major League pitcher Larry Jansen died this week at age 89. Although he was one of the leading pitchers in the National League in the 1950s, he has been all but forgotten by the American public. Students of sports history primarily remember him as the winning pitcher in one of the most famous games in baseball history, the New York Giants' 5-4 victory in the 1951 one-game playoff with the Brooklyn Dodgers that determined the senior circuit's representative in that year's World Series. This was the game that featured Giants outfielder Bobby Thompson's dramatic walk-off home run in the bottom of the ninth inning, the so-called shot heard round the world. Jansen had pitched a scoreless top of the ninth for the Giants. During his 9-year major league career, Jansen won 122 games and lost 89 with an earned run average of .358, solid but not exceptional totals. However, his career began in a blaze of glory. After winning 30 games in 1946 for the San Francisco Seals of the minor league Pacific Coast League, a feat matched only once by any professional pitcher at any level during the subsequent 63 years. Jansen was purchased by the New York Giants. After going 21-5 as a rookie, he recorded 18, 15, and 19 wins over the next 3 seasons before compiling a 23-11, 3.04 record in the Giants championship year 1951. What almost no one remembers is that Jansen was also the named plaintiff in an early right of publicity case that contributed to the development of personal publicity rights as a form of property at the time when future of that right was quite uncertain. But for an even more significant decision held down the same year in the same state, historians of the right of publicity might remember Jansen's case as one of the most significant decisions of the post-World War II era. In the summer of 1952, a number of New York vendors were placing cardboard photographs of the New York Giant baseball players in bags of popcorn and packaging them with chewing gum. Presumably, they were doing this with Dodger and Yankees players as well. This practice was separate and apart of baseball cards that were sold that summer by the Bowman and Topps companies that were packaging the cards with chewing gum under licenses obtained from major league players. On August 14th, 1952, with their team sitting in second place 8 games behind their arch rival Brooklyn Dodgers, Jansen and 6 of his teammates, Bobby Thompson, Sal Magley, Wes Westrum, Monty Kennedy, Dave Coslow, and Bill Rigney, and some say Monty Irvin as well, obtained a show cause order from New York Supreme Court Justice Samuel M. Gold requiring the HiLo Packing Company, Inc., rendered HiLo in subsequent judicial decision, and Theater Concessions, Inc., to show why they should not be barred from continuing their practice of placing the plaintiff's photographs in bags of popcorn that were sold to the public without permission from the players. Jansen and his colleagues also demanded $50,000 in damages. Even though Jansen had won 96 games for the Giants the previous 5 years, post-war major league salaries were so low that players usually had to work at regular jobs in the off-season. Jansen was no different, and each fall and winter he worked in a pharmacy in Jackson Heights, New York. There is little doubt that the extra money would have come in handy. As luck would have it, at the Polo Grounds the next day, Jansen blew a 2-1 lead in a game with the Boston Braves when he allowed 3 unearned runs in the ninth inning. Jansen himself and Bobby Thompson both made errors that inning. In fact, after he filed the lawsuit, Jansen's career went into a tailspin. He failed to win another game during the 1952 season and never again had a winning season in the major leagues. Presumably, this was just a coincidence. Jansen and his teammates were represented by Jonah J. Shapiro, a well-known New York sports and entertainment lawyer. Jansen and his teammates were represented by Jonah J. Shapiro, a well-known New York sports and entertainment lawyer. By the time the case went to trial, Harry Horowitz's businesses, Model Airplanes Inc. and Hit Parade Inc., had been joined as defendants, at least one of whom was packaging player photographs with chewing gum without permission from the players. Jansen's suit was technically not a right of publicity action. That term would not be coined until the following year. His action was brought under Section 51 of the New York Civil Rights Law, which was usually characterized as the New York Privacy Statute, and was provided as follows. Any person whose name, portrait, picture is used within this state for advertising purposes or for the purposes of trade without such person's written consent may sue and recover damages for any injuries sustained by reason of such use. The defendants responded by filing a motion to dismiss on the grounds that cause of action because the baseball players as public figures had waived their right to be left alone, which was, they argued, the sole purpose of the statute. At issue were the implications of the decision of New York's highest court, the Court of Appeals in Gauthier v. Pro Football, which had been decided on July 15, 1952, less than a month before Jansen and his teammates filed their action. In that case, Gauthier, an animal trainer, sued the Washington Redskins and others for allowing his act, performed at the halftime of an NFL game in 1948, to be televised by the ABC television network, which was also broadcasting the game. The court ruled in that case that no violation of Section 51 had occurred. Although the court's rationale was a bit convoluted, there was language in the opinion that seemed to suggest that professional entertainers, like animal trainers and presumably Major League Baseball players, waived their right to sue for invasion of privacy under Section 51 because they clearly sought out the public spotlight. The hearing on the motion to dismiss occurred on November 14, 1952, before Judge Cavigan. In a brief opinion, Cavigan agreed with Jansen's attorney that the Gauthier decision had not ruled out of actions under Section 51 when the likeness of baseball players were clearly being used to aid in the sale of non-baseball related items. In that regard, he found the present case similar to and still controlled by an earlier New York case, Lane v. Woolworth Company, 1939, in which the actress Judy Lane had successfully argued that Section 51 prevented Woolworth's from including her photograph without her permission in inexpensive lockets sold in its 5 and 10-cent stores. Judge Cavigan's ruling was appealed by the defendants, but the ruling was affirmed by the Appellate Division of the Supreme Court slightly more than a year later on November 17, 1953. In a memorandum opinion, the five-judge court unanimously confirmed the decision of the lower court without further elaboration. However, by the time that the Appellate Division issued its ruling, the United States Circuit Court of Appeal for the Second Circuit had handed down its landmark right of publicity decision in HiLo Laboratories versus Topps Chewing Gum, 1953, another case in which lawyer Jonah J. Shapiro served as counsel. In HiLo, the court ruled that baseball players had not just a right of privacy under Section 51, also a common law property right in their name and images. As a result, Alien decision rendered the final decision in the Jansen case less significant than it might have been. Without Helene, Jansen's case likely would have seemed much more important and might have played a much more visible role in the development of the right of publicity in its formative era. It is also not clear if Jansen ever benefited directly from the decision in his case. By the time the final decision was handed down, he was pretty much finished as a player. In 1954, he pitched in only 13 games for the Giants after averaging 39 games per season the previous 7 years. And on July 12, 1954, he was unceremoniously released by the Giants and had to return to the minor leagues. It seems unlikely that anyone was going to rush to get in line to pay Larry Jansen for the right of his photo in popcorn bags after the 1953 season. As a case, Jansen vs. HiLo Packing Company has not been completely ignored. It has been cited in 6 subsequent judicial opinions, including the landmark right of privacy decisions Palmer vs. Schoenhorn Enterprises, Inc. in 1967 and the recent CBC Distribution and Marketing vs. Major League Baseball Advanced Media LP, and that's from 2006. It has also been cited in 6 law review articles and the reinstatement second of torts. In many ways, the case of Jansen vs. HiLo Packing resembles the baseball career of Larry Jansen. At one point, it looked like both the pitcher and the case were headed for historical significance. Instead, they both ended up as important parts of the respective historical records of Major League Baseball and the right of publicity, but in the end, neither turned out to be Hall of Fame caliber. This is from the Boston Globe, October 16, 2009. Larry Jansen, pitcher, won famous game for New York Giants. Larry Jansen, the winning pitcher for the New York Giants in the 1951 playoff game decided by Bobby Thompson's shot heard around the world, died Saturday at his home in Oregon. He was 89. Cause was congestive heart failure and pneumonia, his daughter Darlene Green said. Mr. Jansen spent 9 years in the major leagues, making his biggest mark with the Giants during their pennant-winning season. He won 23 games in 1951, including one of the biggest in team and baseball history. The opponent was the Brooklyn Dodgers. The Dodgers stood there at the edge of the dugout, Mr. Jansen told Ray Robinson in The Home Run Heard Around the World. They were yelling at me, Jansen, you could go home now, but strange things can happen in this game, and this was my duty just to keep pitching and hoping. Mr. Jansen, in relief of Sal Maglie, struck out 2 batters in the top of the ninth before the Giants rallied with 4 runs in the bottom of the half of the inning. The 3 on Thompson's homer off Ralph Branca to beat the Dodgers 5-4 in the third and deciding playoff game. Mr. Jansen won 21 games as a rookie in 1947 and finished with 122.89 career record and 3.58 ERA. He spent 8 seasons with the Giants before pitching briefly for Cincinnati in 1956. He allowed Mickey Mantle's first World Series hit, a bunt single in Game 2 of the 1951 series, and he gave up a double to Joe DiMaggio in Game 6, the final at bat of the Hall of Famer's career. Mr. Jansen was the losing pitcher in Game 2 and Game 5 of that series. He spent 11 seasons as the pitching coach for the Giants and was also the pitching coach for the Chicago Cubs. I thought that was really interesting, and I wanted to find out a little bit more about the lawyer for Larry Jansen here because um, Jonas J. Shapiro, he may have been a very well-known lawyer in New York, but it's really kind of strange that he is Bowman's lawyer, and then he's also the lawyer for the group of New York Giants players who are suing, and they can't be a coincidence. I don't think. You guys can tell me in the comment section below if you think that's just a sheer coincidence or not. How did that happen, by the way? I have no idea. Anyway, Jonas Shapiro, he actually died in 1954 in July of 1954 on a golf course. He had a heart attack at the Sagamore Hotel golf course, and it's kind of funny that a lot of heart problems and heart attacks occur on golf courses. You'd be surprised, actually. It's the fifth leading cause of heart attacks. Who knew that golf was so dangerous? I don't play golf myself, but a lot of people do have coronaries on golf courses. So, I thought it was a kind of a healthy game there. Anyway, what do I know, right? As I said before, Larry Jansen is not the first right of privacy case. That actually belongs to Harry Porter, a Olympian from 1908 Olympics, and he's a gold medalist. And I've discussed this at length in other articles and videos here. But what I found interesting is that through all of these cases, none of the judges, none of the juries ever saw ball players or actors or other sports personalities to be nothing more than entertainers, and therefore they did not have the right of privacy because it was their profession to entertain the fans. And in one case, I think I understand that. Today it would be kind of like different, obviously, because the right of privacy, while that term alone and that concept was really foreign in the late 19th century and early 20th centuries, and today it's just common practice. The right of privacy applies to everybody, not just me or you, but to ball players and actors and famous people. And some would argue more so for them than us, but that's a different story. I say it applies to everybody, regardless if they seek out attention or not through YouTube and other things. You do kind of have to separate the job from the personal life of the person, and so that actually first came up, I think, in Roberson versus Rochester Folding Box Company. Yes, that's it. And that was in 1902. And in 1903, you have the Personal Privacy Act, basically as a statute, a New York statute from 1903. And as I've said at length here, that was incorporated into the T206. So if American Tobacco Company wanted a ball player to sign or have his likeness on a baseball card, a tobacco card, he had to sign a quote unquote permission slip with the leading newspaper sports reporter at the time who would go out to the clubs and have these ball players sign their signatures as an okay to have their likeness in a card. And so that was the first time that that actually happened. And that's one of the reasons why the T206 is probably one of the greatest sets of the 20th century. It is actually one of the top three sets, the defining sets of the 20th century. I would actually say that the T206, the 1933 Gaudi, and the 1952 Topps are the three defining sets of the 20th century, and I don't think there's any doubt about that. Uh, Anybody here can make an argument for another set that really defines the 20th century. Let me know in the comment section below because I would love to hear what you guys have to say about that. Again, Larry Jansen, he was a very good signer through the mail. I don't know if he did really any shows. He was from Oregon. I never met him in person, but I did do some business with him over the years. I did some artwork for him, and I do have a number of his autographed cards. This is one of them, and a 1951, or no, it's actually a 1950 Bowman autograph that I also have. Um, I kind of like his 50, but it's small and there's a lot going on there. I much rather prefer the 52 Bowman, but Bowman's really obviously an interesting company too. And I'm not really going to get into the Haley Laboratories case from 1953 in this video. I'm going to save that for another video because that's going to be long and kind of not tedious, but there's a lot to that particular case. And again, I think they're right. I know I'm kind of like jumping the shark here when it comes to this particular case and Haleen, because they do mention it here. I think they're right in the fact that if Larry Jansen's case, if it had started and finished and adjudicated prior to Helene, you would be hearing Larry Jansen's name a lot more than you do now, and he'd be maybe a, either a very, very famous person or he would have been out of baseball completely after 1953. Again, it's kind of interesting they say that his career kind of took a nosedive after this case. You have to kind of wonder if that was a part of it, if that had anything to do with his basically his early departure from the game. And who knows what would have happened if he actually had. I don't think he won his case. It doesn't seem like he did. Just reading the case itself, I'm not entirely sure that that actually happened. But they also said too that the right of privacy was it wasn't really well established in 1953, and it was only afterwards. So, uh, this again is just such an interesting thing, and we don't really tend to think about the right of privacy when it comes to sports players or really kind of famous people. And their images in cards or photographs or whatever and being sold. And I think that has changed quite a bit over the last 50 years, in fact. And it may be that each state has a different definition of the right of privacy and the statute of limitations when it comes to something like the famous person's likeness on a card or a book or a photo or something. So I knew about Larry Jansen's case for a very long time. In fact, I remember when he passed away. He definitely deserves a video of his own. And there was actually a lot of other ball players here that were included in this case that I have not discussed. And I'm not entirely sure again how this all came to be, the back of it, if you will. How did Larry Jansen come up with that the fact that somebody had issued a sports card without his knowledge or his signature? Now, obviously, he would have been involved, I think, in the 1951 and 52 Bowman Haleen case. And I know a lot of other New York Giants players were. In fact, Wes Westrum, in fact, was heavily involved in the Bowman Haleen case in 1951 and especially 1952. And he's actually interviewed in I believe 1954, specifically on this case, and he had actually said that he had signed both contracts, Bowman and Topps. I'm not entirely sure if a lot of these ball players knew exactly what they were doing at the moment. They could have signed anything and said, "Okay, fine, great," and not really realizing, or maybe even some of them taking advantage of the money here that these two companies, Bowman and Topps, were giving them, because actually it was quite extensive, contrary to the belief that these players were not being paid a lot for their likeness here. They actually were. And if you really think about it, um, the average contract, or regular contract for the ball player, was a lot more than what the average person in the United States was making at the time. And Larry Jansen, he actually didn't fight in World War II. He took a deferment to be on his farm during World War II. So Larry Jansen actually did have jobs in the off season, as almost every other ball player did, regardless if it was baseball, basketball, hockey, maybe not golf, but so a lot of these guys actually did have jobs in the off season. I can't think of really any who didn't. Maybe Ted Williams or Joe DiMaggio. Although Joe DiMaggio had a restaurant. For the most part, these guys all had jobs in the off season. They all were just regular, average, everyday people, because you never knew at that point in time if your last season was going to be your last season in the major leagues, and you had to find other income or have a side hustle to support you, and because they didn't have guaranteed contracts when Larry Jansen here was playing, and that only came, I believe, in like 1974 or around there. Again, guys, I think this is really interesting. You can let me know in the comment section below what you think of Larry Jansen or anything that I've covered here today. And if you have any favorite Larry Jansen cards, let me know. I'd love to hear what you guys have to say, and I'd love to hear your stories. So again, guys, thank you so much for stopping by. I greatly appreciate it, as always, and I will talk to you in another video. Have a good one. Bye.